Welcome to The Explainer. So let's dive into a really fascinating legal puzzle. When Parliament writes a law, how on earth do judges figure out what it really means? It's like trying to read the mind of the legislature. And, as we're about to see, the map for how to do that has changed a lot.
Okay, let's kick things off with this absolute classic from way back in 1892. This is what you call the literal rule in its purest, most extreme form. What Lord Esher is basically saying here is that a judge's job isn't to ask, does this make sense, but to just apply the words on the page, no matter how ridiculous the result might be. It's an idea of total, almost blind respect for the exact text of the law.
And here is where that manifest absurdity becomes shockingly real. Get this, in 1836, a guy literally bit off another person's nose. But the law at the time only made it illegal to stab, cut, or wound someone. So, following that literal rule, the court decided that, well, teeth aren't an instrument for cutting or stabbing. And just like that, he walked free. I mean, this is a perfect illustration of how sticking strictly to the words can completely miss the point of what Parliament was trying to do.
So you can see how this creates a huge dilemma for the courts, right? What are you supposed to do when the plain text of a law leads to an outcome that just defies all common sense? How do you respect what Parliament wrote without producing a result that's frankly absurd? Okay, let's get into the toolbox. To try and solve this exact problem, judges over the years developed a kind of toolkit with 3 traditional methods, or rules, for reading laws. Each one really represents a different way of thinking about what a judge's job is. So what you're looking at here is basically a spectrum of judicial thought. On one end, you've got that super rigid literal rule we just talked about. Then, in the middle, there's the golden rule, which lets a judge kind of bend the meaning just enough to avoid a totally ridiculous outcome. And then all the way on the other end, you have the mischief rule. That's where the judge actively tries to figure out what was the problem or the mischief that Parliament was trying to fix with this law in the first place.
In this case, it's the perfect example of that mischief rule in action. A 1959 law was passed to clean up the streets. But here's the catch. What about prostitutes who are calling down to men from their balconies or windows? Technically, they weren't in a street. But the court looked at the situation and said, hang on, the mischief here is the harassment of people on the street. So they decided the act should cover the women on the balconies too, fulfilling Parliament's obvious purpose, instead of just its literal words.
So for centuries, judges kind of toggled between these 3 rules. But then, right at the end of the 20th century, a single piece of legislation comes along and just completely rewrites the rulebook. I'm talking about the Human Rights Act.
Yeah, this timeline really puts that shift into perspective, doesn't it? You can see these old rules just ticking along for hundreds of years. You get a little change in '93, where judges can finally peek at parliamentary debates for clues. But the real earthquake, the big one, hits in 1998 with the Human Rights Act. This wasn't just another tool in the box, it was a total constitutional game changer. And right at the heart of this whole thing is one single, incredibly powerful instruction in Section 3 of the Act. And this instruction is coming from Parliament to the courts. It says you must, wherever it's possible, read all laws, old ones, new ones, in a way that lines up with fundamental human rights. So this instruction, it basically handed judges this powerful new lens to look at every single statute. It wasn't just about avoiding silly outcomes anymore. It was about actively protecting people's rights. And to actually do that, they came up with some pretty radical new techniques. All of a sudden, judges had these powers that, Lord Esher back in 1892, he would have found them absolutely unthinkable. They could read down a really broad term to make it narrower and fairer. They could read in words that weren't even there to fill a gap in human rights protection. And maybe most shockingly, they could even read out or just straight up ignore words in a law if they violated human rights. This is a profound change in judicial power.
All right, so let's see what this reading in actually looks like in a real-life case. The old Rent Act said a surviving partner could inherit a tenancy if they lived with a tenant as his or her wife or husband. Now, that language obviously excluded same-sex couples. So the House of Lords, using this new duty under Section 3, essentially read in the words as if to make the law fair and non-discriminatory. And that small change extended protection to a surviving same-sex partner.
And this quote right here, it just captures that new mindset perfectly. Lord Stain, in that exact case, called it a strong obligation. Now, compare that to Lord Esher worrying about manifest absurdity. We've literally gone from a position of just follow the words to one of actively protect people's rights. it's a whole different world.
Okay, so this, of course, raises a massive constitutional question, right? If judges can just add or remove words from laws, have they stopped respecting the fact that Parliament is supreme? Are they just making up the law now?
I mean, let's be blunt about it. Have the courts basically started doing Parliament's job? It's a totally fair question, and it's one that courts themselves have really had to wrestle with.
Well, the answer is no, not quite. The case of Swift really shows the limits. The court basically said, look, when Parliament's making big, broad decisions about the economy or social policy, and as long as it's not discriminating on suspect grounds like race, then judges should give Parliament a wide margin of discretion. What this means, in plain English, is that the courts still take a step back and defer to Parliament on these big, complex policy choices. So this brings us to the real takeaway here. That old respect for Parliament hasn't vanished. It's just gotten a lot more sophisticated. You could almost see it now as a kind of partnership. Because let's not forget, it was Parliament itself, through the Human Rights Act, that gave the courts this new, powerful role as guardians of our fundamental rights. It's not a rebellion, it's an authorized evolution of their job. And all of this leaves us with one final, big question to chew on. Has the judge's role shifted from being a neutral referee, just calling out the fouls based on the rulebook, to something more like a co-pilot, actually helping Parliament navigate the incredibly complex territory where law and human rights meet? The answer to that really defines the balance of power in the UK today.